I just make this bigger? Oh, I guess you do that. That's interesting.
Are we good?
Hold on 1 second.
Okay.
Why isn't I on? What does that say?
It should be good now.
Okay. Well, good afternoon, members of the great, awesome Workers' Compensation Subcommittee. Thank you for joining, and for those who are on with us, thank you for joining. As many of you know who are accustomed to our Workers' Comp Subcommittee meeting, this is more for observation and transparency, and it's not
Okay,
a
I'm
hearing.
gonna put do not disturb. I'm on a subcommittee.
If you could all, I'm going to mute everyone and then unmute the subcommittee chair so that we can avoid the background noise.
Great. Thank you.
You muted her.
Yes, can you unmute yourself, Doug Valderrama? It won't let me unmute you for some reason. There we go.
That was hilarious. Anyway, I was saying many of you are the usual suspects that join us in our Workers' Comp Subcommittee meeting. So as you know, this is not a hearing. It is a work group for the members. And should we need more information or members have inquiries, happy to whomever we designate to speak. So again, in full transparency, which is why we welcome you all here this afternoon. So with that said, I believe there are 4 bills. We will try to get to each one. This was just an opportunity to have lengthy discussion because there was no time after bill hearings, and with this unprecedented session we're having, I really am kind of surprised I was able to get this one together, all thanks to Laura, who is awesome. Having said that, we're going to start. I don't know if there was an agenda. I believe there was, but we'll just take it in order in the way. I'm going to start with a departmental bill. Laura, if you could just give the members a brief summary and we can take it from there.
Okay, so hopefully you can all see the bill on the screen. This is the UEF departmental bill that extends the sunset for 1 year for the change in assessments that UEF and SIF have. So it extends the bill from last year by 1 year, thereby altering the assessment on certain workers' compensation assessments and awards and settlements that SIF and UEF have, to decrease SIF share by 1% and increase UEF share by 1% in fiscal 2022 only. And the bill would take effect June 1st of this year.
Great. And for those who are in the subcommittee, this is not a new issue. This has been an ongoing issue. And there are probably folks on here, but for members' sake, you guys don't sit on the joint committee that I chair beside Senator Klausmeier, who's my Senate chair. I would also like for her to chair, because there was quite a bit of, there has been quite a lengthy and elaborate discussion on the status of the UEF and where we were last year, where we granted a sunset. And for those who are, just to make it brief, this is simply, well, I shouldn't say simply, they're asking for an extension, but I have been informed and been trying to keep in the loop as much as possible. There was an analyst who had extensive information that I'd like the subcommittee to hear regarding budget-wise and the status of their, them keeping up with what they need to do, and if this is really necessary legislation. So Laura, if you could share that information, or if Jason's here, he could share that information.
Jason Kramer is the budget analyst for UEF. He's not on the call today, but he had shared with me the budget analysis that he put together for the agency. And some of you are probably aware that DLS is recommending that $100,000 of the appropriation for UEF, SIF, and Workers' Compensation Commission, and $100,000 of general fund appropriation for DBM be sort of withheld pending the outcome of a joint study on September 1st of this year, looking at an evaluation of the current structure of UEF, SIF, and the Commission, including areas of overlapping responsibilities, as well as a recommendation of whether the agency should be restructured, including but not limited to resource sharing and merging. And if the recommendation does not call for restructuring, a thorough evaluation of UEF's personnel needs, So as I mentioned, the report's due September 1st of this year, and then the budget committees will have 45 days from that date to review and comment on the report. And then the funds are restricted pending the receipt of the report, would, revert to the general fund if the report is not submitted to the budget committees.
Right. And with that said, it was also my understanding, based on what Laura said by the budget analyst, that the UEF can sustain without this, if I'm interpreting that correctly, and which is why the suggestion was made for withholding 100,000 for these three agencies. So with that said, Delegate Charkoudian, you had your hand up.
Yeah, I was just trying to unmute myself. Thank you. Yes, I did. Okay, so based on the concerns raised in the budget committees, I'm hesitant to move forward with this bill. Can you just talk about how their decision interacts with what decision we might make on this bill today? Laura, I'm sorry. Clearly, I'm looking at you in case you can't tell.
Yes, I can. So the bills are independent. Oh, the bill is independent of the budget process, but obviously, if you all were to recommend passage of this bill, it would take some of the assessment funds from the subsequent injury fund and give that additional amount to the UEF. So they would have additional funding. The report from, I think it was Pinnacle, the actuary, found that the UEF would have enough funding for a couple years, that it would not, at least my understanding is that the department would not need additional funding to pay out its claims over the next year. So I think the thought was that potentially to hold off on this bill, let the report come in, making recommendations about sort of overlapping responsibilities, potential restructuring, and then next session, if necessary, there could be legislation to make those changes or to sort of more structurally address the shortfall that UEF has been experiencing.
Okay, so I think that I would move unfavorable on the bill if we're at that point, Madam Chair, or you want to hold off for more conversation?
Well, I saw Delegate Aarons's hand
Oh, sorry, okay.
right before you. Were you finished with your inquiries?
That was my question. Yeah, I'm good. Thank you.
Delegate Aarons?
Yeah, my question is, didn't we just say that after the report is due September 1st of this year?
Yes.
And wouldn't that be addressing, if that report comes back, wouldn't that address the issues the delegate has? Depending on how it comes back, or is that just going to automatically let it go forward?
The funding is being withheld pending the receipt of this report, but that's separate from this bill, which takes money out of the assessments
Oh, okay. I
on
misunderstood
awards
that.
and settlements that employers and insurers pay. So it is withholding like money that the state is appropriating versus the bill, which takes some money that is taken from assessments and settlements, like at the end of a workers' comp case. And it's taking essentially money from the subsequent injury fund, what they get from those assessments in assessments, and giving more to UEF.
Okay, I misunderstood the report. Sorry.
Was that all your questions, Delegate Aarons? Laura, if you could either refresh or remind the subcommittee members of how long this has already been ongoing and why the sunset was even.
The bill, let's see. As of July 1st, 2020, the increase and decrease in assessment went into effect, and it was set to terminate June 30th of this year. So what the bill would do is extend the termination date to June 30th, 2022.
If this were, okay.
If it were to pass. Mm-hmm.
I believe I had inquiries prior to this meeting with regard to, what was it now? I can't think off the top of my head. It was, what Jason had said, the budget analyst, with the suggestion that was made, I think I'm repeating myself, but with the suggestion that was made for the study and that UEF could sustain for now, if, God forbid, they couldn't, which again, doesn't look like that is the case, we could always come back, correct? But right now, this ask right now in this legislation is not quite, according to budget analysts and council, that is adamantly necessary. Am I misinterpreting that?
That's my understanding. I know Mr. Burns is on the call, but I believe the report that came back made it clear that they had at least enough funding. I think because of the legislation last year, they had enough, money to pay out claims for the next couple of years. So I think that there was no question that they would be able to cover, any claims that came in, at least in the next year. I don't want to speak for the department though, because, I'm not that expert on that, but that was my impression in talking with my colleagues in DLS.
Okay. If Mr. Burns is here, I will allow you to, brief, ever so brief, if you would like to share if you have new information with the members that are here. If he's here. Is he here?
Let's try this again. Hi, Madam Chairman. I'm here. Can you hear me?
Yes.
Oh, excellent. Hi. Good afternoon, committee. Briefly, in the interest of honest disclosure, the fund should be solvent for 4 to 5, 6 years. The reason this needs to be done is because the original purpose of this was to provide a 1-year financial boost to the agency, but also see what the effect would be of a reallocation of the assessment monies to see what that would do to the SIF, the Subsequent Injury Fund, as well as the Uninsured Employers Fund. And because of the pandemic, obviously, everything got kicked off kilter. My estimate was somewhere around $3.8 to $4 million of assessment money should have been obtained through this, and the fund should have gone up. Actually, as of December, the amount of money we received from the assessment, in spite of it being higher this year, is down from the year prior to that. And that's the COVID. That's the COVID thing. So in order to obtain the funding that we believe was the intent of the original legislation and to support the fund, the bill was introduced. As the Pinnacle study says, should the legislature do this year, it is estimated that it will actually generate $5.2 million in monies going forward. That would mean that the fund would be solvent into the next decade, the 2030s. Should you not do this, this fund will, in all probability, become insolvent in this decade. It's that's the bottom line with it. But no, we're not going to go out of business in the next year.
Delegate Charkoudian and then Delegate Mouts. I'll go with Delegate Mouts first. Is that okay? Okay, since he hasn't asked.
Thanks, Chairman. I've got a pretty simple question, and I think most people already know the answer except me. I'm trying to verify. I want to make sure I'm certain. Where is what is the source of the assessment? Where does the assessment come from?
Both the Subsequent Injury Fund and the Uninsured Employers Fund receive assessments on most settlements and orders of the Workers' Compensation Commission. The Subsequent Injury Fund receives a 6.5% assessment. The Uninsured Employers Fund receives a 2% assessment. This legislation, which was Senate Bill 8 from last year, is enacted, had a 1-year switch in that. The Subsequent Injury Fund assessment went to 5.5%. The Uninsured Employers Fund went to 3%.
So the assessment is paid by the claimant?
By employers and insurers.
Mm-hmm. And the idea is if this bill is not voted through, that the financial status of these funds will balance out so that the assessment may go down in the future? Is that, or is it just that we really don't know right now and we want to wait a little bit longer? I mean, is that the argument against doing something right now?
That's my understanding based on the budget analyst's report, because I mean, Mr. Burns did just say that if it didn't, they would be solvent insolvent, or in some, which he used in less than a decade, whereas if it were, it would be a decade. However, again, I'm going off of our budget analyst and the information I had received. And whether it's less than a decade, where I think the number was used was 4 years. Is that right? Or around 4 years or such that, I mean, the UF could.
That's what Mr. Burns said, 4 to 5 years.
Yes.
So the,
Yep.
Okay.
That's that,
Right.
and that is an estimate based on best guess, but clearly it's reflected in the Pinnacle actuarial study as well. So I think it is based on sound economic principles to say that.
And when was the assessment first instituted? When did it go to 5%?
Well, the assessments go back to the original legislation in approximately 1983 for both the SIF and the UEF. Originally, as near as I can tell, the legislature believed back in the early 80s that the SIF would be the agency that required funding, and the uninsured employers fund would not really need funding because the legislature in the 80s had the quaint notion that because it was the law of the state of Maryland that employers have workers' compensation insurance, they would do so, and we would be rarely needed. And that has just not been the way it's played out. The uninsured employers fund is much more active, I'm sure, than anyone in the 1980s thought it would be. We've also had to, and this is very important to understand, we also cover self-insured entities that go insolvent. And for the uninsured employers fund, that includes the A&P supermarkets and, most importantly, Bethlehem Steel Corporation, which adds literally hundreds of claims and cases to the fund with no source of revenue. So the Beth Steel and A&P have played a significant role in the fund's current funding situation. As far as I know, the 2% and 6.5% go back 20 years.
If
Thank
I may,
you.
Delegate. Okay, thank you, Delegate Matz. Laura, if I, just based on what he said, that they cover other claims and the like, but that was all taken into consideration when the, okay, I just want to make sure that was all, because I know which I totally get. I just wanted to make sure all of that was covered and researched when they made their suggestion about the study and keeping withholding the 100,000, correct?
yes.
Okay. Delegate Charkoudian.
Thank you, Madam Chair. I didn't know if you were ready for a motion on the bill. I was, based on even this additional conversation, I was ready to move unfavorable.
Well, okay, a motion was made, but we can't move unless
I'm sorry?
a motion was made, but there to be is there?
Second, Madam.
I'm sorry. What?
Second.
Oh, there was so there was a motion made and a second. I believe we need to take a roll call, Laura.
Yep. If you could just raise your hand so I can see.
You
All
want
in
to,
favor
like
of the
literally
motion?
raise our hands.
Yeah, I guess, do you want to say all in favor of the motion?
Yeah, I think I'll just go with that. We'll be like, all those in favor of the unfavorable motion, say aye.
Aye.
Are there any opposed? One.
One opposed?
Two?
Two opposed?
Three. So it's 4-3.
4-3? Is that correct? 4-3?
That's, I believe that's, I'm surprised Delegate Polari didn't say a word, but okay.
Okay.
Okay, now I have a question, although but I believe my question was answered before when I had my inquiries prior to the meeting, that with this motion that we made that has passed, not the legislation per se, but God forbid, within 4 to 5 years of which the estimate was, something like this could always come, we could always introduce again, correct?
Yep.
I just wanted to make sure. Okay. With that said, that House bill is moved. Second on the agenda would be the medicinal cannabis workers' compensation option.
Okay.
Thank you.
I'm going to share a screen. Okay. Okay, so House Bill 683 is actually jointly assigned with HGO. This is the bill that expressly authorizes the Workers' Compensation Commission to require an employer or its insurer to provide medical cannabis to an injured employee receiving workers' compensation benefits as part of medical treatment. The bill also clarifies that related to medical cannabis, a claimant may be denied compensation benefits if cannabis was taken, but not under written certification of a certifying provider or the written instructions of a physician. The bill applies prospectively and may not be applied or interpreted to have an effect on or an application to a claim arising from events occurring before October 1st, 2021.
Thank you, Laura. I just want to make clear, like during the hearing, it's my understanding, and this is the point, I wanted to have healthy discussion on this because I know, for instance, if I may, like Delegate Ahrens had inquiries that I thought were relevant, and he really does want to understand this concept here. And I just want to remind members that the bill is not we're not recreating anything. We already know we have a medicinal marijuana program. This bill simply adds medical cannabis as an option. Regrettably, the impetus for this bill, it's not the first time it's come through, but for submission on my behalf, there was a gentleman that testified, Mr. Aaron Shepard, who unfortunately couldn't be with us today. He's actually in physical therapy right now. But there are a couple folks, one is his nurse and one is Miss Christy Magna from the commission and an attorney, I believe his name is Jason Slotkin, who are here. And I would really encourage, if there are any inquiries, that they be made here in this forum regarding this legislation. Are there inquiries? Delegate Matt, you have your hand up. Is that from the prior bill? Oh, okay. I was trying to see, I can't see everybody on here. Does anyone have?
Yeah, I do.
Madam Vice Chair, you do?
Thank you. So for Mr. McAllister, who I know is here, and then certainly happy to hear from the insurers. Have there been a case, or anybody that can answer, I'm not picky, but I'll direct it to Mr. McAllister for now. Is there evidence that some commissioners have, in fact, allowed reimbursement or payment for use of medical marijuana?
Can you hear me?
I can.
Okay, the answer is yes, there is. John Kelly, who was one of the people that spoke at the hearing, went to the commission, persuaded a commissioner that it was a viable treatment option. The insurance company took an appeal to the Circuit Court for Carroll County, who affirmed that decision. It was returned to the commission. And the second time in, the employer insurer said, we shouldn't have to pay for this because it's illegal under federal law. And so the commissioner ordered reimbursement of the claimant so that the carrier wouldn't have the appearance of having paid directly for something that's illegal under federal law. So the answer is yes. The problem is not every commissioner agrees with the commissioner in that specific case. So, and unless there's a statutory permission, which this bill does, other commissioners perceive themselves unable to do so. And actually, if this bill fails, we'll probably cite the failure of this bill as, see, we're not allowed to do.
So explain to me, because I don't practice workers' comp and only know enough to be dangerous. When you say that the claimant was reimbursed by so the claimant paid and then the insurer had to reimburse. Is that the way it worked?
That's the way it worked. And that was the way the commissioner worked around the problem of ordering a carrier to pay for something that's illegal, which would potentially expose the carrier to criminal prosecution. I mean, there's all sorts of laws indicating that's not going to happen. But to prevent any risk of that, the workaround was just reimburse the claimant.
Okay. And then Mr. Enton and Ms. Egan, we've spoken about this previously, but I wonder if either one of you could sort of, either or both, Ms. Egan, I obviously got your copies of your written testimony, which we had online anyway, but tell me why insurance companies wouldn't like the process of just, indicating they can't be ordered to pay, which would require an amendment probably to this bill. Insurance companies couldn't be directed to pay, but they could reimburse if the commission indicated that the treatment was appropriate. And you're muted, Mr. Enton. I see you speaking with it.
Yeah. So I think, if you, in our testimony that we gave at the hearing, and maybe Ms. Egan can give you the citation, but to use my good friend, Mr. McAllister's words, we could work around it. And I'm not comfortable as an attorney. I wouldn't advise a client, look, this is a crime under federal law. But you know what? You can work around it by characterizing it in this fashion instead of that fashion. What bothers me about this bill most is that we have a very, very robust cannabis industry in the state of Maryland. My law firm represents the largest grower in the state. And they've, everybody that's involved in this industry has made an election that, notwithstanding federal law, I'm going to be in this business. And maybe they rely on the fact that there haven't been any prosecutions under federal law for some period of time, whatever. But I just wouldn't want to be in that position if I was somebody that I would have a mandate to arguably, maybe Mr. McAllister's right. Maybe that's clear, but I'm not comfortable with it. It just seems to me that you're either directly or indirectly facilitating the sale of an illegal drug that's illegal under federal law. I just don't think people should have to be put in that position. If they want to reimburse, fine, they can go ahead and do it. And maybe some are. But to be mandated until the federal law changes, I just don't think is appropriate. And frankly, I would be surprised under the current administration and the current Congress that we won't see legalization, at the federal level go through. But until then, I think it's kind of premature. And I don't know the number of cases. I think Mr. D'Alessandro testified or gave us information that, the number of cases that where claims they have are very minute. And it just seems to me that, in fairness to everybody, it shouldn't be mandated. So that's my argument.
All right. Ms. Egan, did you want to briefly, did Mr. Enton cover it, or did you have something to add?
Yeah, I just would like to point out to the committee that, we're not the only insurers in the state that are raising this argument. Health insurers are not required to pay for medical marijuana. So we keep hearing about the out-of-pocket expenses of the people that were injured, but if they weren't injured on the job, their medical carrier are not covering their treatment under medical marijuana. So it's not just us, it's your health insurers as well. So there's a reason that we all take that stance. And that's one of them. The other part is the lack of FDA research on the efficacy of the drug itself in treating that. And there's no clinical studies like you would have with the COVID-19 vaccine that we would hope that would do the same thing for medical marijuana.
Thank you.
Thank you, Madam Vice Chair. If I may, at this point, just based on the two that just spoke, is Mr. Shepard's attorney on here? Yeah, are you here? Okay, maybe not. I wanted him to talk to what Mr. and Ms. Egan said, but Olga, I believe you during the testimony, I know you're the nurse, but I believe you had spoken to what the two just said before you. And if I am incorrect, please correct me, but I would like you to, because obviously it's not legally federally, but this has been ongoing. It's not, Mr. Shepard's not the first and only patient. So if you could just, whether it's in direct response or what have you,
Sure. Hi, my name is Olga. I'm a registered nurse. I'm also a cannabis nurse in the state of Maryland. I've been doing that for about 2 years. I just wanted to speak to the lack of research. There actually is quite a bit of research. It's just a lot of it is coming out of Israel. But there's a lot of cannabinoid-based research showing the benefits of cannabis, especially for pain management. and they're easy, like easily Googleable through the NIH and everything. You can definitely pull up all kinds of research studies. There's been quite a bit, not just there, but also there's the showing how much of a drop of using narcotics when you get onto cannabis. So in this country, they're showing that there's at least a 25% drop of use of narcotics, which is also a cost savings, because especially when you're using heavy duty narcotics, injectables and things like that you see a lot of the time after surgeries.
Right. So I'm
cheaper.
sorry to interject because I'm
Oh,
trying
no,
to
go ahead.
get in as many hands and in the time that we have. But we were talking that other states, we wouldn't be the first to be covered, that would cover it, correct?
Right. There is another state. I know the lawyer was he should speak that, but there
I
is
know
another state.
he was trying very hard to be here with us. But in any event, okay. Thank you, Olga. So I'm going to take it in the order of Mr. Lanier and then Delegate Aarons, Impalaria, and Charkoudian.
I'll be very brief. So just to follow up on what Mr. McAllister said, I actually tried one of these medical cannabis cases at the commission, and the commissioner awarded the benefit. The way that we did it was we submitted proof of what he was using, and the commissioner authorized a specific amount per month. And then we would submit the bill or the receipts of the payment that was under the amount the commission had awarded to the carrier for reimbursement to the injured worker. So that's how it worked, with a little more specificity. So than what Mr. McAllister, because I've actually tried a medical cannabis case and got the commission to approve it. It was not appealed by the insurer. The case was later settled for other reasons. And in that settlement, there was an allotment for non-Medicare related medical expenses specifically for that. As for the
Which
prosecution,
county was that?
Pardon me?
Which county was it?
Well, it was a commission case. It was any appeal would have been to the Baltimore City, but it wasn't heard on appeal.
Okay.
But with regard to the prosecution, one of the reasons that I believe, one of the support I had for the legality of it is two things. One, at least when I tried the case in 2020, the appropriations bill in the federal government said, we're not prosecuting anybody who's under a state medical cannabis program, period. And the second part was, I said to the commission, we always have revisionary power at the commission. If any carrier finds out that they're subject to any sort of prosecution, get a target letter from the federal government, they can always come back to the commission and say, hey, things have changed. That never happened in my claim because that insurance company I assume never got any sort of whiff that there was ever any concern about any prosecution. They simply reimbursed the gentleman every month.
Okay, so it's my understanding, and I apologize to the delegates who have their hands up. It's my understanding Mr. Shepherd's attorney is on this call. Mr. Plotkin, are you the attorney?
Yeah, I just got available here.
Oh, okay.
Hi,
So
everybody.
were you able to hear the testimony of the insurers and the attorney regarding, since it's not legal on the federal level? Were you here for that?
Sure, I caught the tail end of their discussion and Mr. Lanier's response, which is where I would agree with about the prosecution and the revision powers of the commission. I would also like to add that in Pittsburgh, actually the fire department, the city of Pittsburgh treats medical marijuana just like alcohol, and firefighters are allowed to use medical marijuana for PTSD. So it's being widely adopted in several different areas, even outside of workers' compensation. But PTSD would essentially be workers' comp in that instance.
Okay, so it wasn't so much Mr. Lanier, but I appreciate what you just said, but there was statements made that because it's not legal on the federal level, that one would not be comfortable because mandating that they be reimbursed. I believe that's what Mr. N was saying. Am I incorrect in what he stated? Were you here for that? If not, it's okay, because then
Yeah.
Okay.
But it's my understanding that some carriers are already reimbursing. So the comfort level I think is already there. Now, it might not be on everybody, but there's probably some carriers that aren't comfortable with reimbursing significant amounts of opioids as well. and they still do it.
All right, so I'm going to take the delegates in the order that I suggested, but I also would like to call on Mr. D'Alessandro and the head of the commission, Mr. Carl Alman, who I'm glad to see is here with us, or at least I thought I saw him here with us. So after the delegates, thank you. Delegate Ahrens?
Yeah, Chris, as you and I've had, Delegate, I'm sorry, Madam Vice Chair,
Okay.
or Chair. I've had conversations, and one of my biggest problems with this bill is I have some relatively personal experience with this in that I've been to a couple centers. And the biggest problem I have, even with the decision, and I voted for medical marijuana, is the ease of getting it. Literally, where I've been on a couple occasions, I can walk in and say, gee, my nose is bleeding, I need medical marijuana. Now, I'm going to hear arguments, and I've heard these arguments that it doesn't happen, but that's bull because I've seen it and I've been there. So my problem is that if we're going to handle this type of bill the way we've handled medical marijuana in this state, then this is a very, very bad bill because everybody will be getting workman's comp and they'll be using medical marijuana. And I'm not saying, and I also have personal friends that are in dire need of this and they use it, and it is a real tool for them. It's really helpful. And when I think it was Mr. Lanier was mentioning, you can get this now. I think Mr. McAllister said it. It needs to be looked at harder. It needs to have people oversee it better because it's just not working in a medical world the way we've asked it to work for the public. Because we have become, when I ask one of these people, why would you ever legalize marijuana? You're already doing it. And essentially, that's the way I see a lot of these dispensaries. And that's not everyone. And I don't mean to discourage everyone because I'm sure there are some good actors out there. But that's the biggest problem I have with this bill. And no one's been able to address that option and that way out, if you will, for somebody to just go in and say, I got an ache and I need it. And by the way, I'm hurt. I want marijuana.
Is Miss Christy Magna on here? She's with the MCCC. Christy, are you with? There she is.
Yes, I am.
Okay, so to Delegate Ahrens'
Yes.
point, where again, he said that not everyone is a bad actor, but is it that, and he says he's witnessed it, so I can't say otherwise, but that easy, and I could see the deterrent in him supporting legislation like this, but if you could respond to his commentary.
Absolutely. I'd like to make 2 points in response. First of all, in workers' compensation cases, there are extra protections and safeguards put in place. A person who is looking to have medical cannabis reimbursed in a workers' compensation case cannot just walk into a licensed dispensary and get directed to somebody to obtain the cannabis. There are at least 3 checkpoints, and that would be the insurer's attorney, their not attorney, their medical person has to say that the medical cannabis would be reasonable and necessary. The patient's medical provider, as well as that would have to be ratified by one of the commission certifying providers. On the second piece of other people going into dispensaries and being told, oh, you have whatever you're claiming, you can go to this provider and they'll give you medical cannabis. It's not like that. What the dispensaries, I believe, from my understanding, are doing is, since we only have a limited amount of certifying providers, it's not every physician or nurse practitioner or one of our 6 provider categories that can provide medical cannabis that can even recommend the patient for medical cannabis. So I believe the dispensaries are merely trying to provide a linkage to where they could go in their area to have an in-person assessment and to see, do they have one of the qualifying conditions? Would they even be somebody who could benefit from medical cannabis? So number one, we have all these safeguards and checkpoints in the workers' compensation cases. And then secondly, outside of those cases, you have to still go through an assessment and meet all the requirements in order to get medical cannabis.
Delegate Ahrens, did you have?
Well, I did. Christy, thank you for having a conversation with me in the past. I do appreciate that. I guess I understand that, but there's no guarantee that it won't be the same doctor. There's none of that. And based on what Mr. Lanier was saying, there is a vehicle to do this now. And based on his comments, it was a successful way to do it. And, you know, you have to have, if what was just said, if we do those things, then any reasonable insurance company would have to look at it in that manner. And I guess I fall back with Mr. Hinton on some of this is still not a legal product. It's still an issue in so many ways, and it may come around, but I do not have the confidence in what's being said, because I do know that a doctor is a doctor, and these people are going to doctors who have medical degrees to get this currently. And it has become more of, yeah, it's okay, but there might be an easier and better way of addressing this as opposed to marijuana. And I'm not a marijuana person, so keep that in mind. I'm not a big fan of it.
Well, Delegate Aaron's, I have a question just so I'm clear on your stance, because I know you and others are saying it's not legal, but it is legal medicinally. So when you say not legal, you're referring to the reimbursement portion, you know, that.
Correct.
Okay.
Correct. Yeah.
All right.
Well, and marijuana is not legal. Maybe medicinally it is legal because we've done that. But I'm saying how we're using it medically is not something that I would jump up and say, gee, this is the greatest system we ever put in place as legislators. I do see some failings in it personally. And could I be proven wrong? Yeah, but I'm also proven right based on experience. Not that I do it. I don't do it. It's not something I'm into, will never be, but that's just my personal experience being somewhere.
Okay.
And by the way, I just inhaled, but that was to live. I was breathing. Sorry.
All right. I'm going to have Delegate Impler, Delegate Charkoudian, Mr. Almond, and then Mr. D'Alessandro.
Yeah. Thank you, Delegate Valderrama. So, you know, I see this as Maryland is truly a sanctuary state when it comes to marijuana. It's against the federal law. We've passed laws despite that, but we're a sanctuary state for that, and it's still against the federal laws. There are states right now that are becoming sanctuary states for the Second Amendment, for gun rights. And they're basically saying that you can go to this state and you can have a gun, whether the feds say you can have a gun or not. But this is different. What we're now saying is the gun supplier in that sanctuary state now is required to sell guns to people who aren't allowed to have guns, causing them to lose their federal firearms sales license. And this is no different. We're telling these insurance companies, you now have to participate in this system, which federally is illegal, and you can face the ramifications of that. They're not voluntarily doing this. Right now, yeah, we're a sanctuary state for marijuana. So if you want to sell it medicinally, we'll give you a license. You can participate in it. This takes it one step further. What this is saying is if you don't want to participate in it, we're going to force you to participate in it. So the guys selling it, they know they're taking that chance, as Mr. Enton said. And I don't think it's fair to tell these insurance companies that they have to participate in something that is federally illegal. They have federal requirements with their insurance companies, and it puts them in jeopardy, and it puts them in future lawsuit situations. Look what's happened with the opioids, where people were given opioids, and that was legal, and the damage that it's done to people's lives. So for us to force these insurance companies to pay for something that right now isn't legal, it's wrong. If the feds want to make this legal, then it's something different. But, you know, I don't think anyone should be forced to participate in something that we're considering a sanctuary, just like we do with illegal aliens, just like other states do with guns. That's my
Undocumented
feeling.
immigrants, Delegate Impler, undocumented immigrants.
Okay.
Madam Vice Chair, if I may, we are far from sanctuary. 35 states
I
have a
agree.
medical marijuana program.
I agree.
I can't think, so that doesn't make us a sanctuary.
Well, anyway, I want to hear what Secretary Ullman has to say about this.
Okay, so Delegate Impler, I appreciate your comment. I am with the Vice Chair. I don't believe we're a sanctuary state, but I, you know, obviously everyone's entitled to their entitled to their opinions. Having said that, I know. So I have had discussions as well with insurers and the like, and I know they're doing it now, right? So when you say we're making them, it was also said in the original testimony by our nurse who's with us, Ms. Olga Reed, that these folks have to be prescribed the marijuana. It's not like they're just willy-nilly, hey, yeah, sure, you want some weed? Here you go. You know, it's not like that. So there are, you know, limitations on who can get this. So I will respectfully agree or disagree with you on that. Delegate Charkoudian was next, and then we'll go to Mr. Almond.
Thank you, Madam Chair. Yeah, I want to back up and sort of see if we can put this in context. I get that there's a lot of nuances and details we may need to work out, and I'm interested in the state that currently does, you know, require insurance companies to cover prescribed medical cannabis, and to see sort of if there's legal nuances to that statute that we might learn from. But before we kind of get into those weeds, I do want to back up and just be really clear about the opioid crisis that we are in as a country. And to Delegate Impaleria's point, that is technically legal and an absolute tragedy that has destroyed lives. And there is no evidence that medical cannabis does any of the negative things. And so we have sort of two possibilities for supporting people and treating people in pain. One of them, we have a history, one of them is officially legal across the country, and we have a history and a devastation and devastated communities and devastated lives and devastated local, you know, some economies. And the other doesn't have any of that track record, but is illegal for a whole at the federal level, is illegal for a whole host of kind of bizarre historical reasons. And in this state is not illegal. In this state, we have recognized the value of medical cannabis, and it is available. And I think, to Delegate Aarons's point, the fact that it may be widely available, the fact that there may be flexibility in getting a prescription doesn't mean there's flexibility in getting insurance coverage for it. And I think what we're trying to do with this bill is find a way to say, we have two different ways of treating pain. One, if it goes wrong, is catastrophic. And the other, if it goes wrong, maybe it doesn't work out so well, but it's not as catastrophic. And I think it's a moral imperative that we look at what are the strategies, what are the legal strategies that we can put in place that make it more likely that people will be able to go down a path that lets them manage their pain without having catastrophe in their lives. And so I feel like it's important for me to sort of at least reorient myself to that place. And then I appreciate that there are potentially other questions and legal structures that we may need to put in place to make sure that that is possible. But I do think that it's too easy to get caught up in, is there another state and what's happened, and lose sight of what it is that we are trying to support and what it is that we are trying to prevent. And I think there's lots of blame that can be pointed to, and there's lawsuits all over the country about who's responsible for the opioid epidemic. But I feel today, right now in this moment, somewhat responsible for future addiction if we don't find ways to support a pain management system other than one that depends on opioids.
I appreciate that, Delegate Charkoudian. If that was more, as we all know, that was not a question. She was making a statement. So, Delegate, okay, you asked the question. Delegate Mouse, is that from a former? Okay, so I know you have a bill here, and so let me take you and then go to Mr. Almond.
Well, I think I'm going to double time on that. I've got two computers here. So if you see me, I'll probably turn my camera off. You know.
Oh, okay.
But so for anybody, how is CBD oil or CBD? Is that ever prescribed through workman's comp? How's that treated?
Go ahead, Olga.
CBD oil, actually, that would be a nice thing to have covered because you don't get the psychoactive effects from CBD oil, but you do still get the healing properties. CBD oil would still test as positive sometimes because sometimes it still comes up like THC, especially if it's whole plant. And you'll get that same, like I said, that same pain management and all the good anti-anxiety, whatever you're treating with the CBD and CBD plant and CBD edibles. So that would be nice to have those covered as well.
Yeah, but my question was, currently, does Is CBD oil something that's prescribed by workers' comp?
No, because it still falls under the cannabis.
Yeah.
I mean, it can be, but it's not covered right now.
Yeah. And I kind of understand, I guess I got a little statement. I guess I understand, the pros and the cons of the bill, but, the discussion was made about opioids and our responsibility as legislators and things like that. But, that the use of opioids in the treatment, the pain management, that's for the medical community. To me, our job as legislators is to focus on the laws and make sure the laws are consistent and accurate. And I just have a real problem, supporting something that would sort of upend other areas of our healthcare reimbursement and things like that. I get it that the other places are doing it, and maybe we're not there, but this is the use of marijuana. I mean, it has not been. There are problems with the way it's been put into the community, and so I've got some very serious concerns about the bill, just from a legal perspective, how this works in the system. And I think our responsibility is to make sure that we're reinforcing the laws of the state. I understand that there's this push for medical marijuana and to try to bring it into workers' comp, but it's a very complicated situation that we're dealing with. And I think by trying to implement this and do workers' comp, it's kind of like a back door, right? And I've got some concerns about that. And but thank you for answering my questions about CBD. I wish I always had positive things to make everybody smile. I think our job as legislators, and we're making the law here, and the law's got to be consistent. And you get compensated for workers' comp for medical marijuana, but you can't in other parts, in other medical situations. And the underlying issue, I think Delegate Ernst brought it up, is we've got a conundrum until the federal government, turns the page. We're really on, what do they call that? We're skating on thin ice, so I just wanted to share that. But thank you for.
Okay. Thank you, Delegate Mounts. Again, appreciate your opinions as well. And I'll just reiterate that, yes, it's not legal on the federal level, but we are not creating medicinal marijuana as an option. It already is an option for medication and if I use the word simply, because I think it is that simple, that we're simply adding it as an option for our Marylanders who are suffering from opioid addiction and other medications that are killing them, unfortunately, because of addiction. So having said that, this is why I wanted our chairman to be here with us and the insurers, so that it's my understanding, if I've misspoken, please correct me, that there are neutral stances, whether in opposition or in support, but this is already occurring. So with that, thank you, Mr. Ahman, for being with us this afternoon.
Thank you, Madam Chair. Pleasure to be here. Can you all hear me?
Yes.
Great. I just wanted to point out a couple of things. The commission obviously doesn't prescribe anything. We take the advice and the evidence as presented to us through medical experts. And going to Delegate Dumay's question about what happens, one commissioner may decide this or may decide something else. It's based on the medical information that's presented to each commissioner. It might be that in a particular claimant's case, a doctor says, yes, medical marijuana is appropriate and it's recommended. But the other side may have another opposing view. And that's what we take into consideration. It's not the commissioner who's saying, no, I'm opposed to this. And that's how we're moving ahead with this. That's not what the decision is based on. And there are a number of instances, as Mr. Lanier said, and I believe Mr. McAllister as well, that the commission has approved medical marijuana as a modality. Also, there are any number of instances where insurance companies and self-insureds have decided that they will pay for it, and therefore it's not objected to, and it's approved through the commission then by an order. So I just wanted to clarify those various points that, the commission is already taking this particular kind of medication into account when the evidence is presented and approving it.
Thank you so much, Mr. Alman. Does anyone have questions for Mr. Alman? Seeing none. Mr. Dalla, oh, Madam Vice Chair, you had a question?
Well, actually, not so much a question, because I do think that Commissioner Alman answered or presented it in such a way that it is keeping in mind that the commission is serving in a judicial manner, and they're taking in the evidence and therefore, determining whether or not a particular medical treatment, whether it be opioids, medical marijuana, physical therapy, whatever the case may be, both sides have an opportunity to present, and the commissioner is the arbiter and the one that makes that decision. The only thing I wanted to add is, because I don't think any other leaders on this call, although Vice Chair Valderrama, you may have been on the Judiciary Committee. I listened to the testimony for at least 5, if not 6 years, as we considered enacting medical marijuana, because for the bills were jointly assigned to the Health and Government Operations Committee and the Judiciary Committee.
Oh, yes, I remember.
I figured you might have been there for part of it at least. But the first individuals that testified in favor were David Brinkley and Don Murphy. It was a bipartisan presentation that indicated that even nobody might be able to tell you why it works, but for whatever reason, there are people that find relief using what we call medical marijuana, which is not let's go smoke a joint and, get high. It's, you go, and I also chaired an interim committee a year ago to sort of look at the legalization of marijuana, which is not what we're talking about here. But as a result, there was a field trip in Colorado, and I got to sort of see what they looked at. And I've certainly been to the Maryland dispensaries, and when it's medical marijuana, it's not let me buy a bunch that I can smoke. It's, what sort of, how much can I buy and in what form? And generally speaking, it is an edible form. There are smoking forms, but it's, very controlled. And again, it's going to have to be presented to a commissioner to say, a medical professional said that this will help alleviate my pain. And the important piece is it may help alleviate my pain instead of opioids. And so, again, it's not a slam dunk. This is just sort of suggesting we codify what is already, the commission's already considering. If a medical professional treating the claimant is indicated that this is something that will help them. And it's expensive.
Yes.
The reason why the medical professionals are, looking for reimbursement, not the medical professional, but the claimant's looking for reimbursement, because you can't just say, well, go get it yourself. You can, and I'm sure some do, but the bottom line is it's expensive. And if it is truly treating the claimant's injury that resulted from the injury in employment, then I think we should let the commission make those determinations, but make it clear that it is acceptable.
Thank you, Madam.
That's my speech of the day.
But duly needed. So thank you. If I could ask Mr. Plotkin really quickly, if you could just share with the members how Mr. Shepherd has spent out of pocket, and those who were in the hearing already knew he's experienced severe addiction, and really the injury that he sustained has left him in pretty much a permanent situation. So just to explain why we're seeking this remedy in dollars, if you could just share how much he has.
Sure. I don't have a specific
Right.
dollar amount, but I believe it's in the thousands of dollars range.
Okay, it was my understanding it was like in the tens of thousands, but
Okay, then you're probably more accurate because it's not being reimbursed
Okay.
right now, so we don't have an accounting.
all right. And he's not with us, right? He didn't jump on at any time. Okay.
I don't believe so.
Okay. Delegate Matz, is that a hand up from before? Yes. Okay. I would like to get to Mr. D'Alessandro. Are you here?
Yes.
Yes, because I know I've had with the commission and with insurers, and it's my understanding that with the exception of some, at least specifically the Chesapeake, if I misspeak, correct me, that you as in Chesapeake, not you, Carmen Del Sandro, have not taken a specific stance one way or the other. Is that correct?
That is correct. You can hear me, I assume?
Yes.
That is correct. We did not take a position. First, believe it or not, as big as Chesapeake is, we have not had one request for reimbursement ever that I'm aware of. But the reason that, and I understand and agree with everything Mr. Enton said, and the reason I took no position is Chesapeake, unlike other insurance carriers, is Maryland's residual market, which means we can't turn down risk like other carriers. So when the producers and the growers and the dispensaries seek workers' compensation insurance, we have to provide it. So we've already made the decision there to go with state law over federal law. Now, to Mr. Enton's point, did I get an opinion from a bunch of attorneys whether I was violating the RICO Act? Yes, I did. And it's an equivocal opinion. But we made the decision based on that. I made to recommend to my board and CEO that we would provide workers' compensation insurance. So based on that stance, we did not take a position on this bill because I certainly did not want to seem inconsistent in our positions.
Great. Okay. Thank you, Mr. D'Alessandro. So, Delegate Ahrens, is that from a former question? Or
no, it wasn't. I was really wanted to ask the lawyer, Mr.
Sure.
Plotkin. Just real quick for you. Are you there? Jason.
Jason?
He's there.
Yeah, I'm here. Sorry, I'm navigating a couple things here.
You know, and please understand, Delegate Valderrama is very sincere about this, and I'm sincere about it also. Based on the information we've heard today, your client, has he ever really gone through the process of what Mr. Lanier talked about? Has he gone through and got these certifications and gone to a commissioner? And I don't know if he's insured by Carmine's group or not, but just has that ever happened?
Well, to that point, I'm going to want to get into specifics about his case, especially with.
Okay, but has he ever tried the approach that we've just talked about actually worked?
Oh, well, that's actually, it would be the same type of thing. So I don't want to talk.
Okay, that's fine. I appreciate that. I don't want to violate any HIPAA laws. Okay, thank you. That's all.
Okay, Delegate Ahrens. And Delegate Bouts, you have a question.
Yeah, I just wanted to make sure I was on point. Is Nancy Egan still on this?
Yes.
So Nancy, can you hear me? Yeah. So I turned 50 this year, right? It's great stuff. You know, so I go to the doctor and I just want to try to articulate what I was saying earlier. So I go to the doctor and the 50-year-old back and the doctor offers, well, there's one way you can treat this as medical marijuana. That's great. I'd love to do something about my back. So he prescribes it for me. I've got the state health insurance, the Blue Cross Blue Shield. So will that health insurance cover the cost of my medical marijuana?
Yeah.
Nancy.
Currently, the national health insurers are not covering medical marijuana.
Right. So if we were to put this bill into law for workers' comp claims, the workers' comp would be reimbursed, but everybody else who's out there is using medical marijuana, they wouldn't be reimbursed.
That's correct.
So I know, I mean, so we're creating one group versus the other group. Is that accurate? I just want to make sure I'm accurate about that.
Yeah, I think that's why it was sort of jointly assigned to House Economics and HDO, because there is that element that it's being considered a medicine, and therefore it would be coming under their purview as well, not just as a workman's comp issue, but also that, you're going to be signifying that this is a medicine under the workman's comp law, but not designated as such under the health insurance law. So.
And I should know this, but can you buy medical marijuana with a credit card?
No, that's because of the federal laws, banking laws.
Right, so there's no other, you can't buy, you can only pay cash for it. Is that accurate?
Right.
Yep.
You
I
can
don't
tell I
know.
don't use, you
I'd
can
have
tell
to
I
ask,
don't use medical marijuana.
I have to say that I would have to defer. I think some of the state charter banks can handle some of this, but not the federal banks. That's not my area of expertise, so I'd have to defer to someone else.
Yeah, no,
I
the
do
federal
know that
banks
right now
cannot. And in fact, I think it's only the state chartered banks. And I think even with that, there's only one in the state that will, in fact, at least it used to be just one in the state that would even accept the deposits from the medical dispensaries. I mean, the banking, but there was federal legislation, and I don't know, maybe Mr. Renton knows better than I, that I do think passed that does allow a little more leeway for dispensaries and how they handle cash, or maybe it didn't pass and they're still working on it. But that's a problem. I mean, it's a cash business and there's no place to put the cash.
Which is kind of, I mean, so there, if we did this bill, there would be, and probably the majority of the medical marijuana users out there paying cash for it, but we'd be creating this special group that would be reimbursed. And that payment, that reimbursement, does that come from the employers? It comes from your insurance, from your workers' comp insurance, which is paid.
The insurers would pay the claimant, yes.
Right.
The insurers would not be required to pay, the way it's working, would not be required to pay the dispensaries.
The insurers would be required to pay the claimant.
The claimant, not the dispensary.
Not the dispensaries. Okay.
That
Thank you.
answer your, okay. I'd like to, Mr. Kress and then Delegate Charkoudian.
Thank you, Madam Chair. I represent the school boards. I have 17 school boards that collectively self-insure. We did not take a position on the bill. Just to clarify for everyone, a physician cannot prescribe, they only recommend. And just
Read a certificate, right.
Right. And so the one issue you might want to look at is that when they recommend it, you get your card and then you have your card for an entire year. The only thing that raised an issue for us is whether or not a physician is going to be routinely monitoring the use of the cannabis, how long that prescription or recommendation will last. And that is not anything that's addressed in this bill that I recall. And that may be something you want to look at if you decide to move forward with this bill.
And I hate to keep butting in, but Mr. Kress, isn't that really something that the commissioner would do? As far as if a claim for reimbursement is submitted, the commissioner is going to have to make a determination as to whether or not the use is legitimate. And it has one of the questions is, if I was a commissioner, I'd ask is what was in fact the follow-up by the person writing the certificate.
Yeah, so the way the process works is you may or may not have a hearing on the issue. And it may be the insurer is just accepting the claim and you're moving forward with that recommendation. It would then be on the insurer to have a physician look at it and decide whether or not it should continue with its use, whether it's reasonable, necessary, and appropriate.
Right.
So I'm just saying that's the one area that we see that may be problematic for insurers. And like I said, we did not take a position on the bill, but we did discuss it. And that was some of the issues that were raised.
Thank you, Mr. Kress. Delegate Charkoudian.
Thank you, Madam Chair. I think that I want to kind of bring us back to big picture and encourage us to be visionary and bold in thinking about what our role is in combating an opioid crisis, because I think that we can continue to make excuses of why we wouldn't want to move forward. We could talk about the problems with banking and the federal law and the state, and we don't have, Blue Cross Blue Shield's not going to cover it yet. They should, and we should fix the banking problem, and the federal government should fix their laws. But we have a chance to take this one relatively narrow but really impactful opportunity to help people have access to something other than opioids to respond to chronic pain, which can be debilitating, as we all know. And so I'm happy to work on if there's nuanced legal pieces that we have to put together into the bill. I'm willing to support you, Madam Chair, any way that we need to do that. And Madam Vice Chair, I know you have a brilliant legal mind and have helped kind of, thread the needle as necessary. But I think it's very easy. We can continue, if we choose to point to all the reasons that we shouldn't do this. And there's enough, like there are complicated issues. It's a cash business and it's a, and our health insurance doesn't cover it yet. I hope they do soon. But also, or, we could recognize this opportunity that we have in front of us and then find the legal, fixes that are necessary to really address this significant issue that can make a big difference in people's lives.
Thank you, Delegate Charcuti. I couldn't have said it better. Delegate Moutz, is that still your former hand? Okay, with that said, I'm trying not to take everyone's time and we have a voting session in half an hour, but we do have another piece on the agenda. But before we move on, unless there is someone on here who has something to contribute that has not been said at all, please, I'll welcome it in brevity. So is there anybody? Oh, Mr. Erlinson, yes.
Thank you. Can you hear me?
Yes.
Okay. I just want to, we didn't take any position on this bill, but I just point out the concern that I have, and I think employers have concerning a drug-free workplace. Many employers do have post-accident drug tests that are designed, of course, to hopefully prevent an individual from having any accidents or for that matter, hurting other individuals. There already is, there's some legalized marijuana or medical marijuana, and that would have a direct conflict in terms of a drug-free workplace with respect to provisions in the statute that already says that a claim can be defeated if someone is intoxicated, but not defeated if a drug was not administered or taken in accordance with the prescription of a physician. Now, admittedly, physicians can merely recommend the use of marijuana, as I understand it. But when you have that coupled with the fact that if this bill is passed, marijuana is to be paid by insurers, I am just concerned about what does that have the impact on that, the unintended consequences on the drug-free workplace. Therefore, I think this ought to be looked at a little bit longer than what we're talking about now, just that opinion.
I appreciate that, Mr. Erlinson. Thank you for your contribution. I will just say for everyone who is on this Zoom, thank you for being with us. Whether this bill moves, doesn't move, I will say it's not going away because as someone said, it is something I am passionate about. As Delegate Charcuti re-emphasized, we should have more options for our citizens, our Marylanders, and without the stigma of addiction. And unfortunately, the feds haven't gotten smart enough to do what they need to do. But having said that, I'm not saying one way or another how this bill, will proceed in this session, but it is not going away. So I would like to put out there for all those that are on here, the pros and the cons, that just like any other bill, we're going to have to start working on it, extensively so that this can finally move forward, whether it's this session or next. And I will leave it at that. So thank you for the extensive debate on this. With that, we'll move on to the last. There are two bills, but they're pretty much the same bill. And those are the workers' comp presumption bills. Laura, if you could just give a brief background on that.
Sure. You all should know by now that I love comparison charts. So I made a little comparison chart of both the bills. I think that would be helpful in this case. So let me just pull that up on the screen. Okay. Okay. So the members will remember that there were two bills, Delegate Valderrama's bill, which is House Bill 1199, and Delegate Washington's bill, which is House Bill 1247. So in terms of scope, who would benefit from the presumption, under House Bill 1199, that's Delegate Valderrama's bill, there are 5 main categories of workers. So it would be firefighters, advanced life support unit members, paramedics, rescue squad members, etc. The second main category is like childcare workers who are required to provide childcare to first responders or healthcare workers. Next category is education workers, and there are certain types of workers listed there. Then the next would be essential workers, which is defined as individuals who are required to work on the premises of a business or government agency that has been declared essential during a declared state of emergency or under an executive order issued by state, local, or federal authority. And then the last category is healthcare workers whose primary place of employment is a facility licensed by the Maryland Healthcare Commission, or individuals employed in a healthcare, home care, or long-term care setting whose duties include direct patient care or ancillary care or ancillary work, in areas where patients are diagnosed with COVID or treated. House Bill 1247, in contrast to Delegate Washington's bill, is specific to firefighters and sort of the subset that the first subset that we discussed in Delegate Valderrama's bill. There are some differences in the types of personnel, but it's firefighters and police officers basically, and other sort of similar professionals. In terms of the standard that would be applied for each presumption under the House Bill 1199, there are sort of two ways of referencing this. There's the line of duty standard, which is for public safety and first responder occupations, and then the course of employment standard, which is for childcare workers, education workers, essential workers, and healthcare workers. And so under House Bill 1199, having COVID-19 would be compensable in the workers' compensation system if the individual is suffering from the effects of SARS-CoV-2, has been diagnosed with COVID-19 or test positive for SARS-CoV-2, and has duties that require labor or services to be performed at a location other than the individual's home or residence within 14 days before the onset of symptoms. House Bill 1247 has the presumption applies to that group of workers, and it's just the line of duty standard because those are the public safety employees that are covered under that bill. And so I think it's the same actually. Nope, it's a little bit different. So the COVID would be compensable under the workers' comp system if the individual is suffering from SARS-CoV-2, has duties involving direct contact with members of the general public, and has been diagnosed with COVID-19 or test positive from SARS-CoV-2 or the virus's antibodies. So those are the two different presumption standards under the bills. In terms of requirements for eligibility, under 1199, an individual would be eligible for benefits under line of duty or course of employment presumption if the person provides a copy of the positive test or written documentation confirming the diagnosis and shares that with the employer or insurer. And then the date of injury would be set at the date on which the employee was unable to work due to the diagnosis or the symptoms, whichever occurred first. There's no corollary documentation or specification on the date of injury in House Bill 1247. And then in terms of the interaction with other benefits, they're currently under the presumption statute. There are some provisions about how the benefits would interact with retirement benefits that the worker qualifies for. And so for under 1199, the benefits would be in addition to retirement benefits, except that they may not exceed the claimant's weekly salary. And under 1247, I think that my understanding is correct. The bills are different in this way, but I think that the implication is that the benefits may not exceed the weekly salary, but the provision about the interaction with retirement benefits was not amended. So I don't believe that there's that provision there about them being layered, benefits being layered on top of retirement benefits. And then the 1199 establishes or codifies a presumption standard. So the presumption may only be rebutted if the employer or insurer shows that the employment was not a contributing cause of the disease. There's no rebuttal standard under 1247. Both bills have prospective application and both bills are emergency bills.
Thank you, Laura. I'm trying to move my, oh, there we go. Was there any questions or commentary from the members? Okay, seeing none. I actually wanted to ask maybe someone who hasn't spoken on the trial lawyer side, your stance, and then someone from the, what's the legal terms here, Madam Vice Chair? I can't think of it.
The employer, insurer, and
defense.
the claimant.
Yeah, employers, yeah. Claimants, attorneys, and employers.
Yes, thank you.
Employees, attorneys.
I'm having a brain freeze. Is someone from the,
Other than Mr. McAllister, do we have another claimant's attorney?
Yeah, I'm here.
okay,
I don't know if Jim's still on.
He is.
The other Jim.
go ahead, go ahead.
I'm still on.
Matt Pavolone also.
No.
We have lots of representation on this.
Okay, if
subcommittee.
someone could, okay, let me just preface by saying, I know a lot of you like called me, emailed me. I get it. Presumption's not an easy hurdle, but at the same time, again, not the attorney, working with the advocates, I understand the premise for it. And again, not an insurer. So I expected all of the pushback, but again, I wanted this conversation.
Sorry, excuse me.
Oh, you're fine, Madam Vice Chair. So having said that, okay, I know what I submitted, so no one thinks I've lost my mind. But, we're here to do a job. So with that said.
Okay.
Delegate, it's Jim McAllister.
Oh, McAllister speaking, okay.
Okay, I had a long conversation with Carmine D'Alessandro. All the stakeholders had a big meeting last week as a result of Senator Klausmeyer getting us all together. I anticipate, only because I'm an optimistic man, that we will have some compromise on several different ways of approaching this sometime early next week. So I just wanted to let you know that conversation took place this morning. He's meeting with his stakeholders. I've talked to mine. So I think some of these issues may be resolvable by consensus among the people that currently disagree.
Awesome. Cool. Great, thank you.
And I would also add, you also encouraged us to get together and get as much kumbaya moment as possible as we can on this bill.
Yes, thank you. Jim Lanier, was he speaking on your behalf as well? Okay. Is that right? Mr. Daly, I know you had comments. For,
Can you hear me? Madam Chair, can you
Yes.
hear me?
Actually, can you speak louder?
Sure. Sorry, I don't think my microphone is too good with this. So on behalf of the Maryland Defense Council, what our concerns are that the bill is not supported by what we're seeing in terms of the working data. And what I mean by that, and I know that Mr. D'Alessandro gave a very thorough presentation both before you all and before the Senate about the very few number of cases that Chesapeake, as the largest insurer, workers' comp insurers, had that actually have been contested and that have required litigation to go forward. And we have found that it's very much the same situation in the private sector. The number of cases that are, and I'm talking about the Maryland Defense Council, were the solo defense bar in Maryland, civil attorneys defense side, and across the board, our members, uniformly state their clients are accepting these cases that should be accepted. The ones that have issues, meaning that there are evidentiary proof issues, that there's exposures outside of that employment that they've uncovered. These are the cases that are being contested, but that's the exception and not the rule. The other problem we find with both of these bills, and this includes in the Senate side as well, these are add-ons to an existing occupational disease statute. And without going into all the dynamics involved in that statute 9503 was enacted, many years ago to address the unique exposures for those in public safety, police officers, firefighters. That's what it was aimed to do. And it was for what the law would say is an occupational disease, exposure over time, hypertension, cancer, things like that, where there's evidentiary medical evidence that establishes that those, unfortunately, diseases are at higher risk for those individuals given their job. This exposure to COVID-19, whether you're talking about in the public setting or in the employment setting, is clearly an exposure accident. It's not an occupational disease that occurs over time. It's just something. So again, procedurally, this is a problem. And so these are the primary problems that the Maryland Defense Council has with these proposed bills. And you know, that I think that is pretty much what my main concerns.
Okay, thank you. I appreciate your
Certainly
sharing your opinions. In all fairness, I'd like to ask if one of the advocates, is Miss Denise Riley on here with us? Or anyone from the advocacy group, just because this is the opportunity I'm giving, you know, the attorneys, the claimants, the insurers, but I would like the citizens, you know, who are wanting this legislation to speak as well. Oh, there she is. Okay.
Here. Thank you, Madam Chair. Yes, I'm Denise Riley from the American Federation of Teachers in Maryland. We have members who have been exposed to COVID and have lost their jobs and their livelihood due to the disease. They were required to be on the job, and it is now up to them while they are recovering and have no income to try to prove that they got the disease on the job. So we want to be able to protect them. They risk their lives during this pandemic to keep us safe and healthy. And we would like to see that they are protected when they are exposed to COVID.
Mr. Daly, based on what Ms. Riley just said and what you had just said, what would be, you know, is there a way that, and I will get to you, Mr. Kress.
I know that Mr. Kress wants to address this given his affiliations. Madam Chair, what I would say to Ms. Riley's commentary is that teachers, just like any employee in the state of Maryland, have a very good system in place so that if they have a allegation that they've suffered an accidental injury exposure to COVID-19 at work, then they can file a claim form with the commission, and the commission hears all the evidence. Here's the teacher's testimony, takes into consideration all of those factors, and issues a decision based upon that evidence. That's not currently a bar to them. That's why the commission right now, according to Mary Ahern, is roughly 1,190 COVID claims filed. Doesn't mean that they're contested. It means just cases that were filed. So to say that these teachers are not able to get the relief that they're seeking, quite honestly, is not an accurate representation, because they can file a claim. And so and they can get litigated quickly. Usually contested cases about 70 to 90 days out.
Okay, so based on what you said prior to that about how this initially was based an extension on I don't remember the number of the code that you said, but for the first responders and the like. So, you know, they're included in this bill as well, in both bills. So would you say that this could cover, this bill possibly could be for just for, are you saying just for them, or even those persons would have to, you know, follow what the procedure you just, I'm sorry, I have to sneeze, of what you just explained. Sorry.
So yes, this is, so again, without belaboring the issue of the fact that we strongly believe that this is not an occupational disease.
Okay.
And so that's, you know, still a problem with this, but the first responders, just like any employee in the state, would have full opportunity to file a claim. And if in the rare circumstances that it's contested, and again, that's the exception, not the rule, then there'd be the hearing before one of our commissioners to litigate that issue as to whether or not it was compensable on the job accidental injury.
Okay, my last comment or question. So sure. When you say it's not an occupational hazard, but so I used to be a healthcare worker, and if I was still doing what I was doing, which was a respiratory therapist in another life, I definitely would be exposed to COVID? And would that not be an occupational hazard? Because
Let me just explain what I mean by that, because as workers' comp practitioners, we throw around terminology sometimes that is, for our purposes, we know.
Well, I think attorneys do that in general, but.
Well, you're right. You're absolutely right. So let me just explain. It's not I'm not using occupational disease as an occupational hazard. That's just a legal definition of what can be potentially a compensable injury under Maryland law. So Maryland law says under our statute, either it's an accidental injury or it's an occupational disease.
Okay, thank you.
Oh, you're welcome.
Thank you.
Okay, Madam Chair, if I may, I just want to clarify, the American Federation of Teachers is a federation of unions. We represent not only teachers, but doctors, correctional officers, all those.
Thank you, Ms. Riley. And I'm sorry, I didn't see your hand up. I apologize. Okay. Mr. Kress?
Thank you, Madam Chair. I concur with Mr. Daly's comments. I think you should think of this as something akin to an accidental needle stick, where you're exposed to a virus by an accidental needle stick. It's really an accidental injury. It is not an occupational disease. The primary issue with this bill is you're taking an accidental injury, you're shoehorning it into an occupational disease, then you're putting on top of that a presumption. So every positive COVID test will then become a compensable claim, and then the employer is going to have to prove otherwise. So you're just removing the causal connection and saying, this is compensable, Mr. Employer, come in and prove it otherwise. And what we've seen with the school boards is very little claims. And so I would be really curious to see how many teachers have COVID out there, have not filed claims, or have filed claims that have been denied, because we just don't have that data. And so my point is, dovetailing with Mr. Daly said, is there's a process, it's working, and we just don't see any evidence that you need to take this extraordinary step in making these claims automatically compensable just because of a COVID test that's positive.
Okay. Thank you, Mr. Kress.
Thank you.
Bob, before I get, sorry, Mr. N, before I get to you, council has, Laura.
Yeah, I just wanted to ask the group, I've seen sort of NCSL or other publications saying that other states have passed or are looking at presumption bills for COVID. So are any other states in fact handling these claims passing legislation that handles the claims as accidental injuries?
Anyone can.
I was surprised to hear the testimony, honestly, because I had sort of been hearing that other states were doing, approaching the issue the way that these bills approach the issue.
This is Jim McAllister. I received from our national AAJ a 50-state summary of the legislation or case law in all 50 states. I can forward that to you. I sent it to Senator Klausmeier, and it was supposed to be circulated among the people that were talking. And let me just say that we hope to have amendments to these bills next week that will make this a standalone accidental injury, not an occupational disease. And so a lot of the things that you're discussing right now, I think we will be able to work out amongst ourselves. And if we don't, then we should talk about it then. But I'm just giving that in the interest of telling the subcommittee where we stand and what's going on.
Thank you, Mr. McAllister.
What may cut these things. Thank you, sir.
Very briefly.
Bob, let me get to the other Bob.
Okay.
Mr. N. We're cutting it close now, so I don't want to interfere with our voting sessions.
Have a smart Bob talk.
Okay. So are you calling on me, Madam Chairman?
Yes.
Thank you. So let me just say that I spoke with Mr. McAllister last night. Let me just say, I know that Mr. D'Alessandro has been working hard with Mr. McAllister to try to narrow the number of issues that are out there, and I think that's good. But there's a couple of really basic things that I don't think will be narrowed, and I think it's highly irregular for the General Assembly, where there is a statutory presumption, to come in because of one event that's occurred and shift the presumptions and change the burden of proof. and particularly in the workers' comp arena, I think it's very, very difficult when you do that, and it will have a dramatic impact because this COVID is everywhere. It's not something that just happened at this employer's factory, say because a piece of equipment injured somebody. This is everywhere. And the only person who knows where the claimant has been is the claimant. The claimant, knows if he went to a bar, if he went to a restaurant, if he went to a wedding, whatever it is. The employer doesn't know that. The carrier doesn't know that. And it seems to me that, having this presumption to change the burden of proof, there's a reason why the burden of proof is where it is. Burden of proof in normal, on everything just about, is on the claimant. It's on the plaintiff. It's on the party that brings the action. They've got the burden, not the defendant. I think that would really be highly irregular. The other thing I think would be highly irregular is to go ahead and make this retroactive. I mean, this was not the law in March. This was not the law last November. If you're going to change the law now and change people's, we're going to go back now and go backwards. And, what happens to the existing cases that are out there that, were tried where the presumption was what the presumption was and it just seems to me that it's just, I know, that there are dozens and dozens of bills in the Maryland General Assembly this year that, in the title and in the body of the bill, it's COVID this, it's COVID that. But, COVID is, I don't think, and particularly where we seem to be making a lot of progress in dealing with it, should be an excuse to kind of turn a judicial or legislate or a judicial process, or like the workers' comp process is, upside down and on its head. And I think that is just something we shouldn't do.
Okay, thank you, Mr. N. Okay, so in the interest of time, we have a voting session. So I will allow the three young ladies. I will end with our vice chair because she rules. So she's our leader. So Miss Riley, Miss Corson, is that Mr. Pavola? Yeah,
Yes.
Literally 30 seconds or less, and then Madam Vice Chair.
Okay, thank you, Madam Chair. I just wanted to correct that when public employees do get exposed to COVID and report in sick, that the tracing is done by their facilities, and so all the data is actually with their employer, not with the employees so much. So they have the data, and they are not allowed to release it because of HIPAA regulations. So they do have the data.
Thank you, Ms. Riley. Ms. Corson?
Thank you. Real briefly, I represent the Maryland Chamber of Commerce today, their Workers' Comp Subcommittee, but I'm also a workers' compensation defense attorney for the past 25 years. And one thing that strikes me is that I think this entire group would say that we're blessed to have the Workers' Compensation Commission be the kind of body it is and as knowledgeable as it is. And one of the things during the discussion of the marijuana bill is that proponents are basically asking everyone to trust the commission to do the right thing after looking at the evidence. And I would say that the same thing would be true here because the process is already working and the commission is already adjudicating these cases. So I want everyone to remember that that's actually happening, and the commission's been open for live hearings since June because they don't follow the rest of the judiciary. And then the only other point on behalf of the chamber is this would be the first time a presumption is applied to private industry. So, we're very concerned about the application of the presumption of private industry. Thank you for the time.
Thank you. Yeah, thank you for sharing something that hasn't been said. Thank you.
Thank you. Thanks.
Yes.
Matt Pavolu with the Maryland Association of Justice, 39 years comp practitioner. 3 quick points. Mr. Enton makes the point about Why are we taking on these desperate measures? Well, my goodness, we're in a pandemic. We do need desperate measures sometimes when you have a desperate situation. People continue to die with this. So we need to address it. Now, he's concerned about the retroactivity. He'll be pleased to learn, and the members of this committee will be pleased to learn that the group that Carmine, D'Alessandro, and McAllister are working on are matching up sunset with retroactivity. So that will cure any concerns that this will go on and on and on. It's just designed to address a very severe situation. With regard to Mr. Kress's point, that this makes it somehow automatically compensable, that's just not the case. It shifts, it creates a presumption, just like we see in the existing statute 9-503. It creates presumption, but the employer and the insurer have every opportunity to rebut it. And we still have to produce a causation report. You just can't go in there without a causation report representing a claimant. So we do have to show causation, and they have the opportunity to negate that causation at the hearing. So I've taken up my 30 seconds. Thanks so much.
Thank you, Mr. Pavla, and we will end with our Madam Vice Chair.
So I just have sort of 2 points. One, what I heard from Mr. McAllister is that it's part of the compromise may well be that instead of it being under occupational disease, that it may shift to the accidental injury, which I think changes the dynamics greatly and is probably where it should be. The second thing I just wanted to note was, and so one, I hope that the subcommittee waits, and I'd like to see these amendments because I think that will be.
I agree.
I know the plan wasn't to vote today anyway, but Laura, correct me if I'm wrong, but your chart indicated that both bills are prospective only. There's been some suggestion that it's retroactive, but did I miss something?
They're prospective for claims filed after the bill goes into effect.
Okay, so for those that are worried about the retroactivity, that's not what the bill says.
That was not my intent anyway.
And that was the other point that I wanted to make. So I look forward to seeing the amendments because I have a feeling that it probably does represent appropriate and fair compromise.
Okay. Great, thank you. And thank you to whom, I think it was Mr. McAllister. If you could keep me in the loop, and Laura and the subcommittee members, about the discussions that are or have and are taking place with Chesapeake and whoever Senator Klausmeier brought together. That would be greatly appreciated. And I'm really, really appreciative that I can't believe we took up almost 2 hours on workers' comp. Wow.
That's right, it was 4 hours on unemployment insurance the other night, so.
I'll take this over UI any day, but I thought it was actually very productive, and I actually did learn a couple things. And thank you for pointing out your opinion, Ms. Corson, because that actually kind of, that put in the same mindset that the commission is supposed to be doing. But I'll reiterate that I started this not knowing what I was doing. I think we all have, a stance on where this pandemic has taken us. So with that said, members, keep posted because we will be updated with